Hello, my name is Oshin, and in today's video I will be discussing the Criminal Justice Amendment Act 2024. Now, as our group has already gone over the Act's content and its legislative journey, in today's video I want to look at the Act from a slightly different perspective. Unlike most legislation passed on a day-to-day basis, the catalyst for the Criminal Justice Amendment Act, henceforth shortened to CJA, was a High Court ruling. The High Court judgment identified the mandatory sentencing regime for the crime of murder as unconstitutional. This in turn created an urgent need for remedial legislation from the Oireachtas. The CJA is therefore interesting because it not only reflects the legislator's powers to create laws, but it also reflects an exercise of judicial power. And so I will be taking a step back from our report's legislature-centred perspective, with its focus on the debates and amendments of the Oireachtas, and instead look at the Act as a useful case study to explore how the Irish judiciary and legislature interact with one another. To that effect, I would like to show that although imperfect, Hogg and Bushel's concept of constitutional dialogue is a useful framework to capture the dynamics at play in the CJA and its legislative process. To begin, it is worth turning to Bushel and Hogg's classic formulation of what constitutional dialogue means. Dialogue consists of those cases in which a judicial decision striking down a law on charter grounds is followed by some action by the competent legislative body. The term was initially coined in the context of the Canadian legal system, hence the reference to the Canadian Charter of Freedoms and Rights, and in framing judicial legislative interactions as a dialogue, Hogg and Bushel were basically pushing back against the idea that the judiciary is undemocratic in nature by arguing that the judiciary does not ultimately have the final word on the Constitution. On this view, the court does not have the final word if the legislature replies, even if the legislature reply is to repeal the unconstitutional statute or statutory provisions. Even in those cases where the legislature merely implemented a court's ruling, that legislative action could be read as a substantive agreement with, rather than acquiescence in, judicial reasoning. As Siglet, Weber and Dixon point out in their eponymous book, academic debates concerning the idea of constitutional dialogue can be broad, complex, and are often left unresolved. Similarly, my studies for a previous legal skills assignment on the European Preliminary Referencing System also taught me to be wary of the dialogue metaphor. However, I nonetheless think it remains a useful shorthand to describe the relationship between the Oireachtas and the judiciary on display in the CJA legislative process. First and foremost, the metaphor captures a sense of mutual understanding on display between the two branches. This was evidenced by the fact that key actors within the legislative process clearly had read and understood the High Court judgment which had come out 2 weeks earlier. These included the then Minister for Justice Helen McEntee, but can also be seen in the Seanad more broadly. We'll get to the Dáil in a moment. In turn, Justice Simmons' judgment comes across as though it was written with the legislative process in mind, as he preempted many of the points of discussion throughout the Oireachtas. Secondly, given that the CJA demonstrates how imprecise language of legislators can lead to constitutional infirmities, it is not unreasonable to think that Section 2 of the Criminal Justice Act 1990 will come under scrutiny of the courts once more. They in turn will send it straight back to the legislature to try again. In fact, we already know of one plausible scenario. The same issues which plagued the mandatory sentencing regime for murder still remain for the mandatory sentencing regime for treason. So the metaphor of constitutional dialogue captures then that potential for a long drawn out back and forth between the two branches. Now, although I am ultimately in favour of the metaphor of constitutional dialogue, Siglet, Weber and Dixon also remind us, however, that a metaphor is always like and unlike what it is used to describe. Standing in stark contrast to our previous discussion of mutual understanding are the debates in the Dáil more generally, but to be honest, specifically TD Brendan Howlin. Despite Deputy Howling's long-standing career as an elected official, including cabinet positions, mayoral seats, and even being leader of the Labour Party for a number of years, the technocratic nature of the CJA revealed his, and other TDs, complete confusion at the nature of the judiciary and common law more generally. To give one example of Deputy Howlin, he seems to have been under the impression that because the first legislative statute for murder was introduced in 1861, And because no specific statute was introduced to explicitly reference children convicted of murder who have aged out, such individuals would fall into a judicial limbo. This in turn would force judges to revert to criminal law prior to 1860. I have more than likely put more logical structure onto what Brendan Howlin was saying, but that is ultimately what I believe his argument is. Had the deputy read the High Court judgment given by Justice Simmons, particularly paragraph 37, I suspect many of his concerns would have been alleviated. In terms of its content, the CJA is ultimately short, technocratic, and designed to deal with a niche constitutional infirmity. And in terms of its process, it was unremarkable only for the fact that it was passed within 32 days from High Court judgment all the way to enactment. However, I hope to have shown that the CJA nonetheless serves as a useful insight into the relationship between the judiciary and legislative branches in Ireland. Thank you very much for watching my video.